Knowing what a prosecutor must prove at the end after a jury trial is critical to understanding and defending criminal mischief charge. See, criminal mischief could be an indictable crime prosecuted at the county, which can expose a defendant to up to 5 years in prison, or it could be a predicate act used by a plaintiff in a domestic violence restraining order hearing to secure a final restraining order. In both circumstances, it is critical to understand what are the elements of the crime and what a prosecutor or a plaintiff has to prove. At the Bianchi Law Group, we use statutes and model criminal jury charges to review with our clients at the beginning of the case to make sure that our clients know what the law is and what the prosecutor has to prove beyond a reasonable doubt. See, these model jury charges are out there for judges and attorneys, and they're used at the end of a trial after the jury of 12 hears the evidence and has to make a decision whether or not the prosecutor has proven the case beyond a reasonable doubt. And these jurors, they don't have education in the law. They haven't gone to law school. They haven't been given any books. They've been listening to testimony for an entire trial, and then they're expected to ultimately decide guilt or not guilty, just based on the rules and law that the court gives them at the end of the case. And that's the jury charge. So at the Bianchi Law Group, we use these jury charges to make clear to our clients what is required to be proven. I mean, let's call it what it is. These stakes are high. Anybody that's been charged with an indictable crime in the state of New Jersey is exposed to prison. Even the misdemeanors, also known as offenses in the state of New Jersey, carry prison time. And there may also be collateral consequences, like a loss of license, employment, custody, parenting time, a state license, like a financial license or a legal license or a medical license. It goes on and on and on, and the collateral consequences are severe as a result of convictions for cases like criminal mischief. My name is David Bruno. I'm a partner at the Bianchi Law Group. I'm a former Morris County Assistant Prosecutor. I'm certified by the New Jersey Supreme Court as a criminal trial attorney. And I'm a national legal analyst with over 250 national media appearances on networks like Fox News, Fox Business, Headline News, Court TV, Law and Crime. I'm here as part of a team. We are the Bianchi Law Group. We're a team of former prosecutors who aggressively fight the government when our clients are charged with crimes. I want to tell you about a client that we had by the name of John. John was an individual that had an attorney before us and spent 210 days in the county jail. It was a second-degree aggravated assault charge. Bail was high. It was when bail was set. Now it's changed. But bail was high. He couldn't get out, and he spent 210 days in jail on a second-degree aggravated assault. And what we did is once we got in, we had a conversation with the client about the charges, the elements, what needs to be proven, and we compared it to the records and the medical records and the discovery. And we very quickly realized that he was held for 210 days on a charge that couldn't be proven. So that's why we're here. That's why I'm talking about jury instructions. And that's why if you're charged with a crime, you need to think about what needs to be proven at trial in the beginning of your case. So let's go to the model jury instruction on criminal mischief. Now, as you can see up at the top, it's titled Criminal Mischief Purposeful or Knowing, Damage to Tangible Property, and it lists the statute. All right, so you could also look at the statute for 2C:17(3A)(1). There are 7 other subsections that have to deal with other circumstances of criminal mischief. But for today's purpose in video, I will just cover subsection 1. And you could see here, this language is what's read to the jury, literally, right? The court will be saying, in order to convict defendant of this offense, you must find that the state has proved beyond a reasonable doubt each of the following 3 elements. So there they are, right there. That's what the prosecutor has to prove. Starts off with 1, the defendant damaged tangible property. Now, even in the same jury instruction, it'll talk about what tangible property is. This is the instruction that the lay people get in the jury box as to what they have to use to determine the guilt or innocence. And the instruction here talks about the damage. The damage means to cause a loss, injury, or deterioration that reduces the value or usefulness of something. Tangible property means real or personal property that is visible and corporeal, something that can be seen and touched, right? So it's not imaginary. It's got to be tangible. It's got to be real. And it's got to have value. Element number 2, that the tangible property damaged belongs to another, right? So we just scroll down. And we get that. Second element talks about being belonging to another. And then we even have some footnotes here. This footnote 3 is an important one. I'll go down to footnote 3. Where appropriate, charge that property of another includes property partly owned by defendant in which any other person has an interest with which defendant is not privileged to infringe, right? So with that comes up in the context of matrimonial property. Husband and wife own a lamp next to the bed. And let's just say one of the individuals purposely break the lamp. You can't argue that the property was the defendant's because it also has ownership by the spouse, and it frequently comes up in domestic violence contexts. So that's important to know. It has to be the property of another, but the other person could be a spouse who has joint property with the defendant. And then 3 is the mental state that's required. That the defendant acted purposely or knowingly when he or she damaged the property. Now that's a term of art, purposeful, and it appears in our law frequently. Essentially every crime, unless it's a strict liability crime, has the mental requirement, the mental state, mens rea. Purposeful and knowingly are found here. And in the instruction, it says a person acts purposefully with respect to the nature of his or her conduct or a result thereof, if it is his or her conscious object to engage in conduct of that nature or to cause such a result. So it has to be the conscious object to cause such a result for purposeful. And then also knowingly, with respect to the person acts knowingly with respect to the nature of his or her conduct or the attendant circumstances, if he or she is aware that his or her conduct is of that nature or that circumstances exist, or he or she is aware of the high probability of their existence. So it's not necessarily the desire to cause a certain result, but it's the knowledge of the circumstances surrounding the facts that he knew that a particular result or a high probability of a particular result would occur. And by the way, I will put this jury instruction in the notes. So you could scroll down to the description, download it. Also, I'll put an ebook that we created called Understanding the Criminal Justice Process. And if you've been charged, that will lay out step by step what to expect from being charged with a crime to the end disposition. That was written by my team, including myself and my partner, Bob Bianchi. And then finally, what you'll find at the bottom of the jury instruction is the value for grading. All right, value and grading are important because it distinguishes between up to 5 years in jail for amounts of $2,000 or more, jail up to 3 years for amounts to more than 5 but less than 2,000, or up to 18 months for damage that amounts to $500 or less. Right? So the criminal mischief statute and laws broken down right here for you, just like it's given and explained to jurors for indictable crimes up at the county where I was an assistant prosecutor. So you could see what I mean by how important it is to know what the prosecutor has to prove to understand and beat your criminal mischief charges. Thank you for watching. I will also link up at the end of this video, so keep on watching. Next one is my law partner, Bob Bianchi, the former head Morris County prosecutor appointed by Governor Corzine. Served there for 6 years alongside me, and then we left in 2013, started the Bianchi Law Group. Bob will explain to you what to look for in a criminal defense attorney, and he'll break it down. 9 tips, 9 things to look for, and he'll do a deep dive to help anybody that is charged and either needs a lawyer or wants to replace their lawyer, like my client, John, who spent 210 days in the county jail. Thanks for watching. Call the office if you need us. We're here putting out these videos for the benefit of you. Take care.